According to the Collins English Dictionary, 12th edition of 2014, published by HarperCollins Publishers, an economic crime is an action that is deemed injurious to the public welfare and is legally prohibited. Counsel for the defense dissuaded the court not to take judicial notice of the fact that the media is awash with reports of economic crimes in the recent past, as was submitted by the prosecution. In the case of Nimagada Prasad vs. CBI, delivered on 9th May 2013, the Supreme Court of India observed, unfortunately, in the last few years, the country has been seeing an alarming rise in white crimes, which has affected the fiber of the country's economic structure. Incontrovertibility, economic offenses have serious repercussions on the development of the country as a whole, considering a request for the prosecution for adducing additional evidence inter alia observed as under. The entire community is aggrieved if the economic offenders who ruin the economy of the state are not brought to book. A murder may be committed in the heat of the moment upon passions being aroused. An economic offense is committed with cool calculation and deliberately designed with an eye on personal profit, regardless of the consequence of the community. A disregard for the interest of the community can be manifested only at the cost of forfeiting the trust and faith of the community in the system administering justice in an even-handed manner, without fear of criticism from quarters which view white-collar crimes with a permissive eye and mindful of the damage done to the national economy and national interest. Economic offenses constitute a class and apart. Economic offenses constitute a class apart, and they need to be visited with a different approach in the matter of bail. The economic offense having deep-rooted conspiracies involving huge loss of public funds needs to be viewed seriously and considered as grave offenses affecting the economy of the country as a whole, and thereby posing serious threats to the financial health of the country, and in my opinion and finding, which can lead to anarchy, threat to peace, and threat to national security. In Nehru Yadav vs. State of UP and another criminal appeal number 25 of 87, Deepak Misra J, while making pronouncements in Ram Govind Ubadnhoi, that one I can't pronounce, vs. Sudarshan Singh, 2002 Supreme Court 598, the court observed that grant of bail, though discretionary in nature, yet such exercise cannot be arbitrary, capricious, and injudicious, for the heinous nature of the crime warrants more caution, and there is greater change of rejection of bail, though, however, dependent on the factual matrix of the matter. When an individual behaves in a disharmonious manner, ushering in disorderly things which the community disapproves, the legal consequences are bound to follow. At this stage, the cause has a duty. It cannot abandon its sacrosanct obligation and pass an order at its own whim or caprice. In Republic vs. Milton Kablit and 6 others, 2011 Kenya laws, Mkule J made the following observations while relying on the Nigerian case of Alhaji Muhammad Dubuko Asaru vs. Federal Republic of Nigeria, Supreme Court of Nigeria, number 2008 of 2016. Cited with approval of Ibrahim J in the case of Mombasa High Court Criminal number 26 of 2008, Republic vs. Danson Mugunya and another. The criteria in those cases is not exhaustive. The basic consideration in granting bail is whether the accused will attend court once granted bail. The burden whether or not the accused should be granted bail lies upon the prosecution, and the prosecution must give reasons why accused should not be released on bond. Mkule J also observed in the above decision that Section 491H clearly established that bond or bail is automatic in respect of offences punishable by a fine only or punishable by imprisonment for less than 6 months. For other offences, which following the comment by Hobbes in the Leviathan he had referred to, bail will not be automatically granted because of the gravity of the offence. In summary, Section 491H of the Constitution and in the opinion of the court, Section 123A of the CPC clearly delineates the gravity of the offence when it comes to granting bail. That also under Articles 24 of the Constitution, rights and fundamental freedoms may be limited by law to the extent that the limitation is reasonable, justifiable in an open and democratic society based on human dignity, equality, and freedom. Taking into account relevant factors including the nature of the right or fundamental freedom, the importance and purpose of limitation, the nature and extent of the limitation, the need to ensure that the enjoyment of the rights and fundamental freedoms by any individual does not prejudice the rights and fundamental freedoms of others, and the relation between the limitation and its purpose, and whether there are less restrictive means to achieve the purpose. On the principle of being presumed innocent till proved otherwise, the judge held that the principle of presumption of innocence does not, however, mean that one may commit grave offences at will and brag that he is innocent until the contrary is proved. In his view, further, the release of suspect on grave charges such as murder of the petitioners were charged offence both legal as well as public policy. Section 123A is very clear and specific about when a right is curtailed depending on the nature of offence committed. That right to be limited is bail. The extent for its limitation is clear until the charges against the accused have been heard and determined. Hence, to him, Section 123 was saved by Article 42(2) of the Constitution and is still good law. Article 27(1) of the Constitution states, every person is equal before the law and has the right to equal protection and equal benefit of the law. Any finding of this court must benefit or not benefit all the accused in equal measures. Does equality before the law mean equity before the law, considering the social status and income of the accused as argued by counsel from both sides and as the accused are described in the charges when it concerns same bond terms? Evidently, from the description of the charges and argument, all the accused are people of different means. There are those who will meet stringent bond terms and there are those who will not. How can the court then exercise Article 27(1) without being accused of bias? They all face a joint charge in all the case files opened against them. What is reasonable bond when some are bound to afford while others not? Can it be staggered without being accused of discrimination? Section 123A of the CPC is the operationalization section of Article 49(1)H. The legislature, in my opinion, found that Section 123 was not exhaustive and introduced Section 123A in the CPC. In the case of Nimagada Prasad vs. CBI, Supra, I've mentioned it, it was held that economic offense constitute a class apart and need to be visited with different approach in the matter of bail. The economic offense having deep-rooted conspiracies and involving huge loss of public funds needs to be viewed seriously and considered as grave offenses affecting the economy of the country as a whole, and therefore posing serious threats to the financial health of the country, and in the court's opinion, which can lead to anarchy, threat to peace, and a threat to national security, and hence also cases of great national interest. The blunder of public funds leads to reduction of funds actually meant to the greater good of the nation, and also leads to denial of fundamental rights and freedoms as envisaged in Chapter 4 of the Constitution. These actions lead to economic sabotage and deny Wanjiku, the common citizen, basic rights including but not limited to good health, education, employment, food, shelter, and leads to death. In the case of R. Mugunya and all other cases presented by the defense, those cases did not consider the effect of the allegation as stated in the charges upon the community. The charges border on proliferation and theft of public funds meant for provision of services to the community by the state. The court takes judicial notice of the fact that social media has been airing instances of economic crimes on almost day-to-day basis. I will leave it at that. I find that the charges facing the accused persons are grave offenses affecting the economy of the country as a whole and thereby posing serious threat to the financial health of the country and, in the opinion of the court, which can lead to anarchy, threat to peace, and threat to national security. This in itself is a compelling reason why bail should be and is hereby denied. Pre-trial regulations were gazetted in the year 2015. The regulations were meant to give effect to Article 51E of the Constitution, which says to have trial begin and conclude without undue delay. The court has put in place elaborate measures by the way of pre-trial conferencing to ensure speedy trials in these cases. For this reason also bail is denied, as the trials will not delay. All parties are encouraged to participate fully in the pre-trial conferences and allow the trials to hit the road as soon as possible. These trials will not delay. There are hearing dates available as early as in the month of July, which is next month. This ruling will be extracted and placed in all the other cases, as from including case number 8 to case number 17 of 2018.